The letter arrived on a Tuesday tucked amongst the usual bills and junk mail. It was an innocuous-looking envelope government issued a Commonwealth coat of arms emblazoned on the top. But for the residents of the RAF base Williamtown remediation zone just north of Newcastle, it might as well have been a death sentence. This wasn't about a missed payment or a change to their Medicare details. This was about their land, their livelihoods, and the invisible poison seeping into the very soil beneath their feet. This was about PFAS, and the Commonwealth of Australia was about to launch the largest lawsuit in its history, not against a local council but against a global titan, 3M. For decades the sprawling RAF base Williamtown had been a cornerstone of the local community, a source of employment and national pride. Situated near Port Stephens, surrounded by the quiet suburbs of Williamtown, Fullerton Cove and Salt Ash, it was a place where families put down roots, where kids rode bikes down dusty streets, and where the smell of salty air mixed with the distant rumble of fighter jets. Many of the residents had lived there their whole lives, their parents and grandparents before them. They worked hard, paid their taxes, and believed in a fair go, a foundational Australian value that underpins so much of our society. They had no reason to suspect that the very land they cherished, the water they drank from their bores, and the fish they caught in the local estuaries were slowly becoming toxic. These were ordinary Australians living ordinary lives until the shadow of something far more sinister began to creep in. The incident that plunged these communities into crisis stretches back years, even decades. For an extended period, the Royal Australian Air Force, like many defence forces worldwide, used a particular type of firefighting foam known as aqueous film-forming foam, or AFFF. This foam was incredibly effective at putting out fuel fires, a critical capability for an air force. The problem? It contained a class of chemicals known as PFAS, per- and polyfluoroalkyl substances. These forever chemicals don't break down easily in the environment or in the human body. As the AFFF was used during training exercises and actual emergencies on bases like Williamtown, these chemicals leached into the soil, seeped into groundwater, and eventually spread into surrounding properties, rivers, and even oyster farms. The scale of the contamination slowly became apparent not just at Williamtown but at other defence sites across the country, from Oakey in Queensland to Pearce in Western Australia. Residents in these areas began to report health concerns. Local produce was deemed unsafe and property values plummeted. The Commonwealth Government, through the Department of Defence, initiated remediation efforts and compensation schemes, but for many it felt too little too late. The emotional and financial toll on these communities was immense, a silent, creeping disaster that stole their sense of security and trust. The question that lingered in the air, thick and heavy like the smell of jet fuel, was who was truly responsible for unleashing this chemical tide. That question led directly to the halls of justice. After years of dealing with the fallout and facing ongoing legal action from affected communities through class actions, the Australian government decided to turn its attention to the source. The Commonwealth of Australia, represented by the Attorney-General Michelle Rowland, announced in May 2026 that it was launching legal action against 3M, the American multinational conglomerate, in the Federal Court of Australia. This wasn't a small claims matter or a dispute heard in VCAT or NCAT. This was a monumental legal challenge seeking damages exceeding $2 billion Australian dollars, a figure that made headlines across the nation. The core of the Commonwealth's argument was that 3M, as a primary manufacturer of these PFAS-containing foams, knew or ought to have known about the persistent and hazardous nature of these chemicals yet failed to adequately warn users or develop safer alternatives in a timely manner. The case hinged on complex environmental law, product liability, and the duty of care owed by manufacturers. The government would have to demonstrate not only that 3M's products caused the contamination but also that 3M was negligent in its design, manufacture, or warning about the dangers of PFAS. Evidence would likely include internal company documents, scientific studies on PFAS toxicology, and expert testimony on chemical engineering and environmental remediation costs. The stakes were incredibly high, not just in terms of the colossal sum of money involved, but for the principle of corporate accountability for environmental damage on a national scale. Could the Commonwealth truly hold a global giant responsible for widespread contamination? The legal battle against 3M is still unfolding in the federal court, a complex and protracted affair that will likely span years. But the Commonwealth's decision to pursue this record-breaking claim represents a significant shift. It's an assertion that the burden of massive environmental remediation and the human cost of contamination should not solely fall on the taxpayer or the affected communities. While specific monetary outcomes are yet to be determined, the very act of launching such a substantial lawsuit sends a clear message. The Commonwealth is seeking to recover the costs it has incurred and will continue to incur in investigating, managing, and remediating PFAS contamination across numerous defense sites. This includes the immense expense of providing clean drinking water, monitoring groundwater, and compensating property owners whose land has been devalued or rendered unusable. For the residents of Williamtown and other affected areas, while this lawsuit doesn't directly address their individual class actions, it provides a glimmer of hope that the ultimate financial responsibility will be placed where they believe it belongs. It's a pursuit of a fair go, not just for individuals but for the nation itself. The question remains, how much of that $2 billion will the Commonwealth realistically be able to claw back from such a formidable opponent? This landmark legal action by the Australian government against 3M holds profound implications for everyday Australians. It highlights the power of our legal system, particularly the federal court, to pursue justice on a national scale against even the largest global corporations. More importantly, it underscores crucial protections embedded within Australian law that many